Good afternoon, and thank you everyone for joining us for today's bonus call with guest speaker Marc Lane. The topic for today's call is the L3C Social Enterprises Powerful New Capital Formation Tool. We also invite you all to join us for the collaboratory call tomorrow, October 1st at 4 p.m. Eastern Time. The collaboratory is designed to allow participants to come together in a small group setting to actively engage in discussions with other participants on the line to talk about practical implementation of the best practices and tips that are shared with us by our guest speaker today. You will be able to access the collaboratory using the same call number and PIN that you have been provided for today's call. I would like to get our call started today with a purposeful quote from Alexander Graham Bell. Great discoveries and improvements invariably involve the cooperation of many minds. I may be given credit for having blazed the trail, but when I look at the subsequent developments, I feel the credit is due to others rather than to myself. So thank you all again for joining us today, and with that, John A., I'll turn it over to you.
Well, thank you, Julie. I began to hear about the L3C, I'm not sure if it was 2 years ago, a year and a half ago, but when I was in Boston this summer, I was talking to a young philanthropist who was very excited about a project that he had conceived and which his family foundation was supporting him in, and to try to create a capital formation device, they had formed an L3C. And when I went from just hearing about this to actually bumping into somebody that was using a Vermont L3C, I remembered Marc Lane's passion for the L3C, and Marc, this may be unfair, but I'm going to call you the father of the L3C because to me you are the father of the L3C. You may want to, run away from that title, but we have brought somebody who has spent a great deal of time talking and writing and lobbying and teaching about the L3C. So, Marc, our custom in our Purposeful Philanthropy Forum calls is to always ask the guest who joins us if they're willing to share maybe 3 to 5 minutes that would help us understand your professional journey, the odyssey that you've been on professionally that gets you to where you are today. You don't have to necessarily start with law school. You can pick it up wherever you want to. But we'd like to know kind of the background that got you to where you were when the L3C began to emerge.
Well, I very much appreciate that, John, and thank you for your generous comments. Not necessarily deserved, but generous nonetheless. Yes, my involvement in social enterprise, of which L3C forms a part, is really a product of my personal and professional passions. I opened up my law practice the day I was sworn in nearly 40 years ago. I don't recommend that as a career path to the students I teach at Northwestern Law School, but fortunately it's worked out for me. Over the course of those years, I've had an interest in a number of different areas which have coalesced and brought me to the social enterprise and the L3C. For one thing, I've been very actively engaged in counseling clients about entrepreneurship. I've taught entrepreneurial finance. I've written extensively on that subject. So that's one prong. A second is I'm very much involved in socially responsible investing. Our law firm has a series of financial services affiliates. One is an SEC registered investment advisor that has a proprietary approach to socially responsible investing that we call advocacy investing. It in turn is the product of several years of empirical research we did that ultimately was published by Institutional Investor in London in 2005. So socially responsible investing is another prong. Then I'm very much involved in corporate governance. In fact, I just received today the first copies of my latest treatise on that subject published by Aspen, and it's a monster of a book on corporate governance, but I'm very much concerned about issues of accountability and transparency. So when you bring together entrepreneurship, socially responsible investing, accountability, and transparency, as an attorney, you find yourself empowered to engage social entrepreneurs and assist them in driving positive social change and ameliorating social problems. So now I teach the course in social enterprise at Northwestern Law School. I've just completed a book on the subject of social enterprise, which will be published later this year or early next year by the American Bar Association, which for the first time will expose attorneys to the opportunities of social enterprise. And I think that's extraordinarily important because attorneys, in my judgment, should be agents of change. So that brings me to the L3C. I did draft some of the laws, including the Illinois law in my home state. I represent the very first L3C in the country, which is a Vermont entity, but based in New York. I am licensed to practice law in New York as well, as it happens. But we have put together L3Cs now all over the country. I'm sure that our firm does more of this work than any other, and in some cases we're representing the enterprise, the entrepreneur, the foundation, socially conscious individual investors who may come in at subsequent tranches, and even institutional investors. So in each situation, obviously, we have to have only one master to whom we're loyal, but we're finding lots of different paradigms, and the form we see is inviting creativity. So we continue to be very enthusiastic about the ability of the L3C to move the dial significantly as far as social change is concerned. So I don't know if I did it within 5 minutes, but
you're right on target. You're right on target, and really appreciate that background. Your diverse experiences professionally undoubtedly have prepared you to basically create a lot of enthusiasm around the L3C. I suspect that not everybody on the call today, Mark, even understands what an L3C is. So before we start talking about the why you might want to consider the use of an L3C and about the hows that are involved in using one, could you kind of just give us a little bit of a history of the birth of the entity itself, and then we'll come back to some of those key points that you wanted to make in our conversation today.
I'll be delighted to. Thank you for the opportunity. Although the L3C was officially born in April of 2008 with the enactment of legislation in Vermont, and 6 other states have followed suit in the interim, it was a very long gestation. And in fact, the legal history goes back to 1969. The Tax Reform Act of 1969 imposed upon foundations, grant-making organizations, as a trade-off for the tax benefits they enjoy, the obligation to distribute at least 5% of their assets annually for charitable purposes. Up to that point, foundations were realizing tax benefits, yet they were hoarding their assets. They weren't deploying them for charitable purposes, which was really the legislative intent behind the tax benefits awarded foundations. So Congress acted and said, okay, if these guys aren't going to do it voluntarily, we'll force them to do it. So this is what accounts for the feverish competition for grants among charities, because that's how these foundations satisfy their requirement, is by granting, typically to nonprofit organizations. What is less well known is that the same law, the Tax Reform Act of '69, provided an alternative way of meeting the distribution requirement, and that is by making what's known as a program-related investment, or PRI. And the idea here is that so long as an investment is made for charitable or educational purposes by the foundation, properly done, meeting the appropriate criteria, that will count against the 5% distribution requirement. And over all these years, foundations have generally not pursued this opportunity, notwithstanding the fact that one would think it's in their best interest to do so, because after all, when you write a check for a grant, that's an expense. You keep your fingers crossed, hope it gets used wisely, but the money is gone. Whereas if the foundation instead makes an investment that investment, whether debt, equity, or something else, remains as an asset on the balance sheet of the foundation, hopefully to be recovered at some date, and can then be recycled over and over again for charitable purposes. So in being a good steward of the resources of the foundation, one would assume that foundation management would prefer to have this financial multiplier effect and indeed social multiplier effect that the program-related investment offers. Well, for all kinds of reasons we can talk about, that hasn't happened to any great degree. And the L3C is a specialized new form of business entity. And I say business, it's a for-profit that is intended to facilitate program-related investing, to give greater comfort to foundations so as to encourage them to take advantage of the opportunity that one would think in a commonsensical way they would want to take advantage of anyway. So I'll kind of defer for the moment what you then do with that opportunity and how it all works, but that in broad strokes is what the L3C does.
Thank you, Mark. Now, the L3C, let me see if I've got this straight, stands for Low Profit Limited Liability Company. Is that correct?
It is, and I confess that although you've flattered me with the paternity of the L3C, I did not coin the term, and it's not one that I particularly like. I must confess I'm a capitalist, a socially conscious capitalist, but a capitalist nonetheless, and the whole notion of low profit is a little off-putting. But what the intent of the law is, and here we're tracking the program-related investing requirements of the Tax Reform Act of '69, the purpose of the entity must be significantly for charitable or educational objects, and the production of income or the appreciation of assets can only be a secondary motive. Now, having said that, there's no cap on earnings, there's no cap on appreciation, and many of these social purpose businesses that we're organizing, I fully expect will deliver significant financial returns and still qualify. But the low profit comes from that statutory requirement, and it was intended to be kind of a cute takeoff on the 3 being a super text where it'd be L and then 3 and C. But it's low profit limited liability company.
Yeah, let me just ask, Mark, and this I really am going to get to your key points, but I can't resist asking this. Is there any type of corollary principle that comes over into the statutory regimes governing the L3C that would be similar to the private inurement concept over in the nonprofit world? Is it possible and in fact probable that you will have, quote, investor owners of an L3C?
You absolutely will, and that was the original construct. The expectation was that if the foundation comes in for the first layer of investment, the first tranche, as a portion of its annual distribution, the foundation is going to be a patient investor, itself with a charitable motive, and it's important that the interests of the foundation and the L3C be aligned. And the foundation is not bargaining for market rate returns, it's looking for social impact. So it will forego market rate returns. Not unusual for PRI, for example, to have to be a bond with a 0 or 1% coupon, or it may be a disproportionately low equity stake. Well, since the foundation is foregoing market rate returns, the cash flow that is generated by the enterprise can be skewed in favor of private sector players who come in at subsequent tranches seeking market rate returns. So effectively, the foundation is subsidizing the returns of other players for a venture that otherwise may never have existed. And that's really the original concept here. It's a tranched or layered, tiered capital structure where the foundation does the heavy lifting, but the venture, by reason of that foundation investment, can, 1, be established, 2, become sustainable, and 3, can now work toward being bankable. And in some cases, we're even looking at institutional investment. but all by reason of the foundations doing the hard work in the first place.
Thank you, Mark. I can see already just from this first 10 or 15 minutes that we've spent talking about the L3C, some really exciting possibilities that open up, particularly as we think about where socially responsible investing, social enterprise is all leading the world today to try to create greater change. This is an exciting new development, it seems. Let's get to some of the points that I think you felt were very, very important. And the first one, I believe, that you wanted to kind of make was this point that program-related investments, or in the acronym for tax purposes that we use as PRIs, program-related investments have both a financial and a social multiplier that direct grants don't. You spoke to that a little bit, but do you have a story or something that would illustrate that point for us?
Yeah, well, the arithmetic is very simple. A grant is a distribution irrevocably made for charitable purposes. So its financial impact is going to be limited to how the recipient's charity puts the money to work. But it's a one-off. Therefore, from a financial point of view, the dollars are finite, the dollars are gone, and the social impact is in the hands of others. Whereas if a program-related investment is made in a for-profit entity, it can be recovered when the debt obligation matures along with interest, or when the equity investment is recovered through a liquidity event, hopefully with a profit. And that money now returns to the foundation, and the foundation can recycle that money over and over again in perpetuity. So the same dollars are working much, much harder, and in working much, much harder, they have the capacity to drive significantly greater social change. So the concept is really one of leverage.
I see that, and it occurs to me, I love the distinction that you drew, that in the grant, you're in essence turning the responsibility and the opportunity for social change over to others. Here, you have an opportunity to continue to have a voice in that and to see how that whole cycle plays out. Very interesting difference. What about what are some of the struggles that you see in terms of designing, implementing, and monitoring program-related investments?
Let me talk to that, but if I may first kind of cue off the point you just made.
Yeah.
The involvement of the foundation in the social enterprise can actually be even significantly more impactful than purely through the calculus we've just described. In many cases, foundations become social venture capitalists, where they are contributing expertise, talents, infrastructure, relationships to the social venture in which they now have a stake. Further, in the case particularly of a family foundation, we're finding this is a golden opportunity to involve the younger generation. As you may know, I'm sure you know, most family foundations were created solely and exclusively for tax reasons. In anticipation of a family business being sold, typically, an advisor may counsel an entrepreneur to set up a foundation, deposit some shares of the business in the foundation, let the foundation sell those shares and escape capital gain tax, whereupon the foundation will now use the proceeds to pay charitable donations that otherwise would have been made by the family directly. Well, what the L3C does is turn that on its head, where now the family behind the family foundation can roll up its sleeves, get involved, show the next generation what it really means to launch a business and be successful in doing so. It turns the foundation from a passive platform into an active enterprise to drive positive social change. So there are lots of different nuances to what I'm describing, but it seems to me it's a very expansive opportunity that can be adapted on a case-by-case basis to address the specific objectives that might be defined for a family or for any foundation. Now, in terms of the hurdles, what are the tricks or the problems associated with implementing a program-related investment, which was your next question? The foundation is obliged to invest its assets prudently. Understand, too, these are tax-subsidized investments, and they are intended for charitable purposes. So there is a prohibition against wild investing, and indeed there is an excise tax that can attach to the foundation and indeed to its managers for jeopardizing the exempt purpose of the foundation by investing speculatively or imprudently. Well, investing in an L3C, one might argue, is imprudent because we're talking about a startup that is undercapitalized, perhaps with no capital. So you would think it would fall within those jeopardy assessment rules. Well, the program-related investment is a specific statutory exception to those rules. So long as the activity is significantly charitable or educational, so long as it is pursued only insubstantially or as a secondary motive for profits or appreciation, so long as it doesn't engage in political activities or the support or opposition of a candidate, it will qualify because charities, social purposes, charitable purposes of this nature would otherwise not be funded. So that in itself is a charitable purpose, and for that reason the jeopardy assessment rules are bypassed. Therein lies the risk, because if the foundation doesn't get comfortable with the L3C's satisfaction of those statutory requirements, the foundation could be punished by, one, not having the investment count against the 5% distribution requirements, and two, being subject to this jeopardy tax. Well, the way in which this problem has been solved by most foundations is, well, let's just not do it. And the truth is, in the fullness of time, most foundations have never even heard about this. Their advisors may not know about it, and if they do know about it, they don't share it with them because they don't want to embark down a path that may be perilous. Those foundations that are engaged in this activity are finding it working beautifully. And the truth is, I think in the whole history of PRI since 1969, I think I found a grand total of 2 cases where foundation managers were in fact assessed a jeopardy tax. So it's a very rare circumstance for the most egregious of conduct. Yet foundations where they do want to do this will either pursue a private letter ruling, which candidly is impractical. It's expensive, it's time-consuming, it's adversarial, and by the time you get even a favorable ruling, the entrepreneurial opportunity is likely to have evaporated. Or, more likely, the foundation will rely upon an opinion of counsel, and that's the way these typically get done, and we're drafting these opinions every day. And these are comfort letters which lay out what the activities of the venture are proposed to be, how they match against applicable law to ensure that you do in fact have a program-related investment. Well, some of the big foundations have been doing this all along. I mean, you look at MacArthur, for example, or Kauffman. They've been doing PRIs for many, many years. Of late, and of note, the Gates Foundation, which had adopted only a grant strategy about 9 months ago now, has said, no, we really should be pursuing PRIs for the very multiplier reason that I've described. So they've just allocated $400 million, which is chump change to them, but not to the rest of us, for program-related investments. And they are leading by example. They're showing that, hey, it's safe to get into the water and it's something reasonable to entertain. And the foundation community is embracing this idea. The Council on Foundations is very supportive of the L3C and PRIs. And so there is something of a sea change here, and the L3C, I think, is largely to credit for that.
Mark, a couple of things coming out of this segment of our conversation. One is I'd just be curious, because I've written not too long ago about the exciting, I guess you would say, plan that Warren Buffett moved to, where instead of waiting until his death to do a spin down of his philanthropic wealth, he decided to put that wealth into the hands of the Bill and Melinda Gates Foundation, and over a 10-year period of time to see that wealth employed today rather than waiting until his death to begin to have an impact. I'm curious, do you know whether any of Buffett's money is part of the $400 million that has been allocated by the Gates Foundation for PRIs?
Well, I don't know that specifically. You know, these dollars are fungible, and I'm not sure at that point, once it's commingled, how you trace that. I do know that the Gates children, the Buffett children continue to have their own foundations, of course, and his daughter is also involved in PRIs, independent of what's being done with Gates.
Interesting. Thank you for that. And you're absolutely right. Unless there had been some public announcement, there probably is no way ever to be able to trace where that $400 million came from, and if any portion of it is representing
but of course Warren is very much endorsing Bill's strategy here, so Bill Senior's strategy, I guess we might say, and so this is really a reflection of their shared philosophy, I'm quite sure.
Okay, and then the second point I wanted to take us to is you mentioned the support from the Council on Foundations, and that's very important. There are some naysayers, which doesn't surprise me. Any new concept always is going to attract criticism. Could you, without focusing on the criticism, can you, in a minute or two, just kind of crystallize what the critics of the L3C would say when they're kind of making, what they're trying to poke holes at it, or say that it's a statutory gimmick is the words I hear most often, and it bothers me to hear those words.
No, I'd be delighted to, and I think when there is a legitimate criticism, it needs to be dealt with, and if it's less than meritorious, it needs to be rebutted. So there's some of each, and I'm happy to identify both categories and what the appropriate response is in my judgment. One of the criticisms is that it relates to the utility of the form. Given that we have a limited liability company anyway, which can receive program-related investments, and the L3C in each case results from a friendly amendment to the respective states' LLC law. Why not just do the LLC? It's redundant. We don't have to worry about it. My response to that is, yes, it's absolutely true, and indeed program-related investments have been made into LLCs for a long, long time. The difference is that when you have an entity whose articles of organization are constrained to mirror the requirements of the Tax Reform Act of '69 with respect to program-related investing, it seems to me that that helps the foundation in that it satisfies what I would say is the first item on the foundation's due diligence checklist, namely, is the investee entity eligible to receive program-related investments? Even before it gets to the question of how, what specific activities are they going to be engaged in, here we're drawing a line around what the activities of the entity can be, and imposing fiduciary obligations on management to ensure that they don't operate ultra-virus. So I think that is a very helpful step. In addition to that, I think the L3C is very useful from a branding point of view. Many nonprofits through their for-profit subs and in collaboration with for-profits, as well as de novo for social purpose businesses, are selecting the L3C even without thinking they're going to get program-related investing because they want to hold themselves out to the world as a social enterprise. And that that tends to invite consumer support and support from other counterparties. I think it has the effect of sensitizing the foundation community to this opportunity. Until the L3C came along, there wasn't much talk about PRIs. Now all of a sudden we see something of a flood, and I think that in itself demonstrates that there is some value to the L3C form. So anyway, that's one source of criticism. It's unnecessary, it's redundant. A second is it may take money away from the philanthropic sector. People will no longer donate to charities, they're going to invest in social purpose businesses. In fact, I'm going to be on a panel at New York University on October 20th dealing with this very issue. And it seems to me, one, the philanthropic support is too small to really drive the change we need, and it should be used as a catalyst to attract private sector support. And three, to the extent we can have the broadest possible capital funding for the social sector, it seems to me everybody benefits, but there are those who have entrenched interests in maintaining the status quo. I don't think that's an objection on philosophical or societal grounds. I think that may be something of a self-interested objective. Third thing is there is some concern among charity regulators that the forum might be abused, where people may use it as a shill and there are really for-profit motives behind it, and there'll be some device by which foundation money will end up in the pockets of some individuals rather than driving charitable purposes. I don't fault the form for that. I think any form can be abused, it seems to me when those circumstances occur, and they may very well occur, there are regulatory responses that would be appropriate and serve as a deterrent. But I wouldn't fault the L3C for that any more than I would fault the corporation because people in Wall Street don't always do the right thing. It's not the platform, it's the actors behind it that you have to look at. So those are the general criticisms that I hear most often.
Great. And I think if I understood that first criticism in your response to it, it isn't that we're saying you couldn't do this through an LLC, but what we have with the L3C is a vehicle that's specifically designed with statutory protection or guidelines to come inside the safe harbor for PRIs. Is that correct?
That's exactly right. It's tailored for it, and therefore you don't have to worry about will this, from a governance point of view or from a fiduciary point of view, you don't have to be concerned about management strength from purpose in a way that might jeopardize the characterization of a program-related investment.
Well, Mark, could you maybe just kind of segue from this point where we're talking about the governance side to highlight what some of the possibilities are that allow an L3C to uniquely kind of create the balance between the nonprofit and the for-profit stakeholders in the entity?
Yeah, I'll be delighted to. One such example does relate directly to governance, so this is a fairly neat segue. Thank you for that. I've, over my career, set up lots of companies for lots of people, and many of those have been limited liability companies. And I can tell you, when you sit down in a room with the people who are forming a limited liability company, the conversation focuses on how the pie is going to be cut, what the economics are going to be, how the sharing of cash flow and equity would look, and power, who's going to be making decisions. Here, we have the unique circumstance of different kinds of stakeholders coming together from different perspectives, different cultures, in fact, with different fiduciary obligations and different objectives. And you would think it would be a train wreck. But in reality, the conversation, unlike the typical conversation of entrepreneurs joining together to create a typical business, here everybody understands and respects why everybody else is in the room. So there is a unique opportunity to harmonize disparate objectives, manage expectations, and deliver to everybody the benefit of his or her bargain. And that governance point is really driven by the form. If we were to use a plain old LLC, that point might never be heightened. Whereas, given the limitations of the form, the way it's positioned, the brand it enjoys, everybody understands starting out, hey, look, the foundation's going to be looking for social returns. It's going to forego market rate returns. Everybody's going to be looking for a charitable purpose primarily. People are going to be entitled to get market rate returns up the chain. Well, that all gets laid out in front and addressed in front. So I think that's urgently important because some argue that the L3C's principal advantage is that governing feature. So I don't want to neglect it, and I think that in itself presents lots of opportunities. But in terms of different examples I can point to, there are, I believe now, something like 200 plus L3Cs in the country. We are probably in the throes of putting together another 50 in one stage or another. And there is an acceleration, really, of L3Cs. And I can tell you that they are in all kinds of enterprises. More and more we're doing L3Cs that are education-based, and education-based is another way of saying knowledge-based. And when you say knowledge-based, to me what that means is it's predicated on the identification, protection, and leveraging of intellectual property. So I think you're going to see a lot of educational type initiatives, some of them online, that are going to be rolled out where you will have social enterprise franchising. You're going to have strategic alliances where the initial activity is going to be at home base, and then the entrepreneur will seek out like-minded people in other cities throughout the U.S. or beyond and develop strategic alliances or joint ventures to really leverage impact, and generate financial returns back to home base to ensure sustainability of the original venture. Lots of ventures along those lines. We're seeing many ventures that are workforce development, where the real purpose is to take unemployed or underemployed people, put them to work in a business. The business is almost incidental. You're teaching job skills, work ethic, reportability to managers, respect for customers, showing up on time, calling if you're sick. But these people then get trained and mentored and placed. Often there are job placement opportunities associated with these workforce development deals, and we're seeing them in really every possible kind of field. We have one here with Avon, the cosmetics company. We have the very first L3C in Illinois is a civic staffing L3C, a client of ours. They happen to do fair wage day labor with a view towards securing ultimate permanent employment for folks. We're seeing a lot of affordable housing deals. We're seeing adult daycare, hospice, green daycare. We're seeing a lot of international ventures. The PRI rules are quite clear that if an activity is charitable in the U.S., ipso facto, it's charitable when performed anywhere. So we have an L3C that owns a hospital in India. We have an L3C that's setting up a company that's maintaining databases in a private fashion to ensure that individual rights are protected. We're looking at missions and food banks are L3Cs. But it's almost endless. Anything that is charitable in the broadest 501c3 sense works. I'll give you one example which is just unusual that occurs to me that we're involved in. You may have heard that Eli Broad, the prominent real estate magnate, planned on donating his enormous art collection to a museum in California, and ultimately reneged on that promise because the museums at large are suffering financial hardship, and he was afraid that between escalating admission charges and concerns about viability, his stuff may not be shown, or it might end up in a basement. So I got a call from an art museum, unrelated fact pattern, not Mr. Broad, but they expressing the same concern that major donors may rethink their plans. So in one case, what we were doing is setting up an L3C specifically to own a very valuable art collection from a septuagenarian. And the art collection is going to, he originally thought he was going to give it away to a museum, but he said, no, I want to maintain it, I want to maintain control over it, and I want my family to after I'm gone. So what we're doing is we're treating it as any other LLC, and we're fractionalizing it. We're gifting interest in the art on a discounted basis to family members for income splitting and estate planning reasons, and we're having foundations support the exhibit of the art, where the family gets to decide where it's exhibited, in what city, under what circumstances, so they no longer have the costs of insurance, travel, and yet they continue to own the art, and the art gets displayed in a continuing way that is strategic by the family's lights. So that's an unusual application of the L3C. We're using it for sustainable agriculture. There are all kinds of applications.
Mark, one of the other points that you have made is at this time we really don't have any federal law that's specifically tied to L3Cs. If I'm not mistaken, there has been some effort to get some legislation federally that would recognize L3Cs. If that had happened, perhaps there wouldn't be a need for states to adopt an L3C. There would be a federal entity that would serve this purpose. But I'm just curious, what is this Philanthropic Facilitation Act of 2010? What is it about, and how might it make the world of the L3C even better?
Right. Let me first adjust something you had said. There is no expectation or, in fact, desire to have a federal business form. These are all state law, always will be, just as corporations are, partnerships are, LLCs are, and so on. The L3C is a creature of state law, and there's never been any effort to make it otherwise. The intent of the Philanthropic Facilitation Act, which is a bill that is not yet introduced in Congress. Our hope and expectation is it might be in fairly short order, but Congress has a fairly full platter, I understand. But the idea is to create a rebuttable presumption that if an L3C is organized under any state's laws that enable them, it is in fact an appropriate recipient of program-related investments. It's rebuttable, however, and the other part of the law is it would create a procedure whereby any social enterprise, including L3Cs, could, on a voluntary basis, apply to the IRS and secure an expedited ruling that any investment it receives will qualify as a PRI, and it needs to be done within 60 days. So no longer do you have to go through this protracted private letter ruling process, and if the IRS does not act within the 60-day period, the entity is blessed as if they had, and foundations are permitted to rely dispositively on that process. The trade-off for the enterprise is, by applying for that approval, it would agree to make an annual report to the IRS, fairly abbreviated, but it would include financial reporting as well as social reporting. What has it done in the last year on a narrative basis in furtherance of its charitable or educational purpose? So the Philanthropic Facilitation Act, isn't that a mouthful? Another act that I did not name, is not yet introduced. My expectation is that either it will be or something akin to it will be in the fairly near future. I can tell you, however, in the meantime, nobody's really waiting for it. There is greater interest in the L3C and in social enterprises generally now than ever. You know, we have two new benefit corporation forms in Maryland and Vermont. We have a bill introduced in Michigan to have 2 new forms of social enterprise. We have legislation that is moving forward in California for a new form of social enterprise. This is all very much consistent with an overarching trend toward self-sufficiency in the social sector with less reliance on philanthropy or using philanthropy catalytically, which is the way I would prefer to think about it, and less reliance on government because government candidly can't be counted on financially these days. So as there's more people in poverty than ever and more disadvantaged populations no longer being served by charities, this is a way for charities to get into earned revenue approaches that will make them more sustainable, as well as social purpose businesses that see the need, see the opportunity.
Mark, this has been fascinating, and I guess I appreciate what you're saying, that there really isn't any desire, nor has there been any effort to create a federal entity. There are a few federal entities. We see them primarily in the banking area. I know in the old days there were a few philanthropic organizations that had federal enabling kind of legislation behind them in the good old days. But I'm just curious, has there been any effort prior to this yet to be introduced legislation to create any kind of facilitation previously of this under the Internal Revenue Code to kind of give more recognition to what an L3C is?
Yeah, there was an earlier iteration of the currently drafted bill. I was not supportive of that earlier iteration. What it did is allow, one, it was limited to L3Cs and not other social enterprises, which it was just really kind of an unfortunate limitation, because I think that all social enterprises should be supported when they're done for the right reasons by the right people. But it was limited to L3C, and further it said that any L3C is, by virtue of being an L3C, automatically a recipient of program-related investments without question. And I just couldn't imagine the IRS accepting, or Congress for that matter, accepting from a policy point of view that by virtue of setting up a given entity, the burden has now shifted from the taxpayer to the government to establish that somebody's done something wrong. That's inconsistent with the whole of the tax law. The burden is always on the taxpayer.
Right.
Yeah, so I didn't think it made sense, and I thought it was just a bridge too far. And I didn't like the idea that it was limited to the L3C, because many other kinds of entities also should be receiving PRIs, and to favor one over another, I thought was not particularly helpful. But this is, I think, a much better approach to the issue, and I think one that's likely to receive a much more favorable reception once introduced.
Great. Julie, I'm going to ask you if you would unmute your line. I have kind of lost my controls here. My battery on my computer has run down, Mark, and I'm outside to be able to get a better call signal and don't have a means to plug it in. So, Julie, if you would kind of steer us through the Q&A. We now would like to give all of those who've joined us for this very interesting conversation with Mark Lane an opportunity to ask questions or to offer affirming observations or stories in support of what you've heard about the L3C today. So does anybody have a question or an affirming observation that they would like to offer to Mark?
If you have a question or would like to make a comment, please press 1 on your phone and we will open your line.
Mark, while we wait for that, I'm going to mention that for those who have been on the call today, Mark has graciously agreed to meet us again tomorrow afternoon, same time, same station. So the same call-in number, the same PIN that you have today will work for the collaboratory hour tomorrow afternoon. We don't always take a full hour. Sometimes those calls have actually gone as long as an hour and 30-plus minutes. But Mark has agreed that he would be willing to come back tomorrow and really talk with you and with us about the practical side of this. What are the barriers to seeing L3Cs used more frequently, and how can we as philanthropic consultants, philanthropic advisors, and individual and family philanthropists, how can we better utilize this new tool called the L3C? Julie, if we don't have any questions, I'm wondering if Mark, if you'd want to kind of offer a kind of a concluding synopsis of what you feel the opportunity is and the future is of the L3C, what vision you have for that. And we might also share with everybody, Mark has given me some materials that I apologize I had neglected to forward those, Mark, to Julie. Julie will post those on our website. We'll also send those to everybody that was on the call today, so you'll have those materials, which include this Philanthropic Facilitation Act of 2010. With that, Mark is also working on a book that we hope will be published soon that will deal with the topic of the L3C. And I'm sure if you have questions and can't come to the collaboratory tomorrow, Mark is going to be willing to try to steer you to the answers if he can't just immediately find an answer for you.
Yes, indeed. I'd be happy to help in any way I can, of course. As to closing comments, I think the real message I would like to send, particularly to this audience, is we're all in the empowerment business. And the societal need today is truly desperate. And the L3C is one tool among many to really ameliorate social problems. And I think the philanthropic advisor and the philanthropist are uniquely positioned to make a material difference, and to the extent that they can familiarize themselves with the opportunities associated with the social enterprise, L3C and otherwise, I think they will be doing themselves, their clients, an enormous service, as well as those people who are in desperate need for help.
Thank you, Mark. I love that. I love that vision. It reminds me of a book that I read recently that I think the title is something like, "What Kind of World Do You Want?" And the point of the author, James Gregory Lord, was that each of us have a stake in creating the type of world we want. And this is an exciting new opportunity to create greater leverage and impact. Thank you, Mark, for the time today, and we look forward to everybody who can join us tomorrow at 4 p.m. Eastern and 1 p.m. Pacific.
Truly a privilege. I enjoyed being with all of you. Thank you.